Hello and welcome to my channel Happy Hours. In the last video I discussed about the article number 16 to 21. Today I am going to proceed further with the principles of natural justice. Article number 21A, right to education. Article number 22, protection in the case of arrest. There are procedure right, exceptions to it, detentions and its types, rights of those arrested under preventive detention. Article number 23, which prohibits traffic in human beings in Begar. Article number 24, which prohibits the employment children underage. Article number 25 to 28, right to freedom of religion. Article number 29 and 30. So let us proceed first with the principle of natural justice. The principles of natural justice, there are three principles of natural justice. First, no one is the judge of his or her own case. Second, no one to be punished unheard. And the third one, an authority while acting must act in unbiased manner. Thus, while interpreting Article number 21, the court, apart from taking into consideration the procedure established by law, also takes into considerations the due process of law and the principles of natural justice. We are proceeding further with the article number 21A, right to education. Free and compulsory education for the children from 6 to 14 years of age. It was added by the 86th Amendment Act 2002. It was not there in the original constitution. Article number 22. Protection in the case of arrest or detention in the certain cases. There are various dimensions, and the first one is procedural rights. Now we should understand what is the procedure to be followed if a person is arrested or detained by the police. Firstly, the person to be informed of the ground of his or her arrest or detention as soon as possible and has the right to consult and to be defended by a lawyer or a legal practitioner of his choice. Secondly, the person to be produced before the nearest magistrate within 24 hours of the arrest. These 24 hours not to be included the time taken to reach the magistrate or necessary time for the journey between the place of arrest to the place of magistrate place. Thirdly, a person not to be kept in custody beyond the time frame specified by the magistrate. Now we should understand first what is a custody. Custody is also of two types. First is the police custody and the second one is judicial custody. Now what is the police custody? The person is arrested by the police and then the police is granted to interrogate. After the interrogation, the police have to inform the magistrate and then only the other procedures are followed. Whereas in judicial custody, you cannot interrogate. If interrogation has to be done, they have to take permission from the magistrate. The maximum judicial custody is given is 14 days by the CRPs. During the trial also, people are kept in judicial custody. Now there are some exceptions. When these procedures are not used, is that first the enemy alliance, that is during the time of war, the people who are caught during the war, and the second those arrested under the preventive detention law. Now what is that detention? We should understand there are two types of detention. First is punitive detention and the second one is preventive detention. Punitive detention, it is the detention after the crime has been committed and the trial or the investigation has been done. Whereas the preventive detention is here no crime has been committed but the person is arrested on the basis of suspicion. There is a third part, that is rights of those arrested under preventive detention. A person not to be detained beyond 3 months. If a person is to be detained beyond 3 months, then it has to be on the recommendation of the advisory board consisting of the person who are judges, or the persons who were retired judges, or the persons who are eligible to be appointed as the judges of the High Court. If these people suggest the person to be detained for the longer, then only the person can be detained for longer. The person to be produced before the competent authority as soon as possible, and the person to be told about the grounds of detention as soon as possible. Now, there is a query. In the country like India, which is a democratic country, whether there should be preventive detention procedure or not. There are most These are the most misused procedure in India. Our constitution makers were having the opinion that prevention is better than cure. They were having the idea that this procedure can be misused. So they talked about the right of the people who are arrested on the basis of preventive detention. The NGOs approached the courts with respect to the misuse of preventive detention law. Supreme Court held in many cases that the preventive detention law is the violation of person liberty of an individual, that is the fundamental right, and the constitutional safeguards which have been provided in the constitution, they must be respected. They must be followed. Means if the detention is to be extended beyond 3 months, then it has to be after the recommendation of the advisory board. If it is written in the constitution that the person should be told about the reason of his arrest as soon as possible, then they must be told as soon as possible. Even they should be produced before the magistrate as soon as possible. So the constitution provisions has to be followed. The Supreme Court from time to time has taken up the petition relating to the misuse of preventive detention laws. The Supreme Court has held that preventive detention was a serious invasion of personal liberty, and the constitutional safeguard is such matters are not negotiable. The court also held that the detention order becomes bad in law if all the relevant facts about the person proposed to be detained are either concealed or not placed by the police before appropriate authorities. The code also held that the preventive detention is devised to afford protection to the society and in the view of the objective of the power given to the authorities. It is imperative for them to remain vigilant in taking a person in lawful custody at the earliest. Any indifferent attitude on the part of detaining authority or executing authority would defeat the very purpose of the preventive action and termed the detention order as a dead letter and frustrate the entire proceedings. So there is a need for reformations in preventive detention. There is another classification which is right against exploitation. Article number 23(1) prohibits traffic in inhuman being in Bihar. It means engaging in slavery or servitude and to compel an individual, especially the children, women, and the disabled, to do immoral acts like begging, prostitution, etc. Begar is forced labor with or without wages. Article number 23, clause 2 holds that the state can compel an individual to render public service. Example, during election, public servants are asked to go for the election duty. Article number 24. It prohibits the employment of children below 14 years of age in mines or factory or any other hazardous occupation. It has not abolished the child labor, it just prohibits the children below 14 years to work at the hazardous places. It was in the mind of constitution makers that child labor is economic help to the family. That's why child labor is not abolished in the original constitution. The Child Labor Prohibition Regulation Amendment Act 2016. It amended that the Child Labor Act of 1986. It prohibits the engagement of children in all occupation and engagement of adolescents in hazardous occupation. If the child is working for the family business after the school hours or during the vacations, then it is not considered as the child labor. Now there is another query that whether a child artist is a child labor or not. A child acting in or taking part in any advertisement or TV or movies or any sports activities except the circus will not be considered as child labor. But parents must have to ensure that the child is getting his proper education. Now, the article number 25 to 28 is the right to freedom of religion. The article number 25, clause 1, it is providing for the twofold freedom of religion. First is freedom of conscience, and the second is the right to practice and profess and propagate religion. Right to freedom of conscience, inner freedom of an individual to follow a religion, right to practice, to follow the rituals of one's religion, profess, it is to spell out the principles of one's religion, and the propagation, it is also same, but it is not for the education purpose. It is also spell out the principles of one's religion, but it is for the purpose of education, that is educating others. Article number 21, 25, clause 1 is subject to public order, morality and the health. Article number 25, clause 2, subclause A holds that the state can make any law regulating or restricting any economic, financial, political or other secular activity which may be associated with religious practice. Article number 25, clause 2, subclause B holds that state can make any law providing for social welfare and reform and throwing open to Hindu religious institutions of public character to all classes and sections of Hindus. Article number 26, freedom of denominations. Denomination means a group of people following the particular religion. There are being three rights. First is the right to establish and maintain institutions for religious and charitable purposes. Second, right to manage its own affairs in religion. And the third one, right to property, which is again divided in two parts. First is right to own and acquire movable and immovable property. Second one is to administer such property in accordance with law. The rights provided under the article number 26 are subject to public order, morality and the health. We are proceeding further with the article number 27. Taxpayers' money not to be used to maintain a particular religion. In other words, no person shall be compelled to pay any tax to the proceeds of which are specially appropriated in payment of the expenses for the promotion of maintenance of any particular religion or religious denominations. Article number 28 it prescribes whether religious institutions can be imparted in educations or not. For this purpose, Article number 28 has classified the educational institutions in the following categories. First one, the institutions wholly administered or maintained out of the state funds. Here, no religious instructions can be imparted. The institutions which are administered by the state but have been established under any endowment or trust which requires that religious institutions to be imparted in such institutions, here religious instructions are to be given and the students are compelled to undertake that. Example, madrasa or the gurukul established by the trust. Third one, the educational institutions which are recognized by the state or by the receiving aid. out of the state fund. Here, religious institutions can be given, but the students are not compelled to undertake it. By here, I am concluding. Thank you.